I'll make one last comment, if I may, my Lord.
Well, I'll make one first comment, if I may,
right.
Mr. Pollock. We've got to finish this afternoon, of course. You have not yet exhausted the estimates that we were given. We've got to bear in mind, though, that Mr. G has got to be given an opportunity to reply. I don't know, Mr. G, whether you're in any position to offer a time estimate for that.
If we get into difficulties, I'm quite happy to do something in writing.
Well, let's see how we go. But Mr. Pollock, can you bear in mind that Mr. G, I think, ought to be given an opportunity to make oral reply submissions, and we may finish. As I say, you're within your estimate, and Mr. G was, I think, within 15 minutes of his estimate, so we're not doing too badly.
I thought of almost nothing else over the adjournment, my Lord. And I had a look at the notes, and I thought I almost certainly would give Mr. G an adequate opportunity.
Willing. It cries out for further better particulars of adequate.
I make one last comment, if I may, my Lord, on Lord Diplock in Sawyer, which is that the surprising suggestion in Lord Justice Donaldson's approach was that you should equate the concept of inherent vice in carriage and insurance cases, because that was against a background where Arnold said that this was not the case. In other words, this was a new point that was being made. And all I would say, no one had suggested this before, Lord Justice Donaldson did, and there was no authority which supported him, and Arnold went the other way. In those circumstances, I would suggest that it would be remarkable if Lord Diplock was to be taken as in approving that particular part of Lord Justice Donaldson sub silentio, because it would have been known that this was a different point, a new point. Now, my Lord, can I, before I go to the next case, correct one matter that I said this morning? I said, and this is, of course, of very little relevance, but in passing I said that my clients had sent emails about the previous casualty to the leg and sent a report. I was wrong to say they sent a report. It was disclosed and the report was referred to, but we didn't actually send it. But it was when it was drawn to the attention of the insurers that we had disclosed all this, that they withdrew their non-disclosure. It was just, I went over the top in saying we'd sent them a copy of the report. I had misunderstood the position there. But they had been told about the previous casualty. That was the point. Noten, could I ask your Lordship to turn to Noten, same bundle, tab 57. Now, I think my learned friend Mr. G suggested that the mechanism of the damage here was unknown. That's not quite right. What it appears happened was moisture in the gloves, to start with, migrated out of the gloves under the conditions of the carriage, and then migrated back into the gloves as water. So you had moisture in the gloves, moisture out, moisture back in, and that's what caused the damage. Now, Mr. Justice Phillips, all I need to refer to really is that he refers to the fact that all internal vice cases, but one of which to which he had been referred, dealt with damage caused by intrinsic change. And you see that in the right-hand column on page 530, where he says, at the second break, this case has an unusual feature which, to the best of my knowledge, is precedented in only one previous decision. In all cases in which underwriters have successfully relied upon the exclusion of inherent vice, the damage has occurred in the form of some intrinsic change in the goods insured, such as decay, heating, internal combustion, breakage due to inadequate packing, or the bursting asunder of the packing which forms part of the goods insured. And in the present case, then, the goods were cardboard gloves. The damage was caused, skipping a sentence, by the dropping of water from a source external to the insured goods onto those goods. Insofar as the quality of the goods contributed to the casualty, it did so because the goods absorbed moisture before being placed in the container, which moisture escaped subsequently to condense and fall back on the goods. So that was the mechanism. And the one case to which he is referring is the one that appears on the next page, Mr. Justice Wright in Bowring and Amsterdam, London Insurance, where you had a case where heating was caused by water dripping onto the cargo from the ship structure, did that fall within cover against heating when resulted from external causes? So the only relevance from my point of view is that there you have Mr. Justice Phillips saying, effectively, all inherent vice cases involve internal mechanisms, except this one rather unusual one, which is nothing like ours. Now, if you go to the Court of Appeal, tab 58, Lord Justice Bingham gave the main judgment. Now, my Lord, all one needs to say is that Lord Justice Bingham adopted what we would say is the classic narrow approach. We have absolutely no problem with his formulation of the test or inherent vice. 288, as far as Lord Justice Bingham was concerned, he saw no distinction whatsoever between Lord Diplock's formulation in Sawyer and the way it was set out in Arnold. Now, if you look at 288, in the left-hand column, you have the test. If at the top of the page, if the factual cause of damage to these gloves had been correctly identified, then I think it is plain that it was an accepted peril under the policies. The goods deteriorated as a result of their natural behaviour in the ordinary course of the contemplated voyage without the intervention of any fortuitous external accident or casualty. So it's the ordinary course of the contemplated voyage, and what he must mean there in the ordinary course of the contemplated voyage is the ordinary conditions in which the carriage takes place internally in the vessel, without any fortuitous external accident or casualty, and in those circumstances you simply had the moisture in the gloves migrating out of the gloves, and then because you're being carried in a vessel, condensing and falling back in.
Well, there was a bit more to it other than that. I mean, it only came out of the gloves because the gloves and the container in which they were loaded in Calcutta and were very hot, and therefore the gloves would hold a lot of moisture, and the containers were discharged in Rotterdam, where it was markedly colder, with the result that the whole of the container cooled.
Exactly, but that's what you mean by the contemplated voyage. The ordinary incidents of the contemplated voyage are that the goods are going to be loaded in Calcutta, where it is hot and you will get moisture in them, and they're going to be discharged in Rotterdam in circumstances where if there has been any moisture that has migrated out, it will migrate back in.
Is that equivalent to saying that if you could prove that on some voyages that didn't happen, then it shouldn't have been inherent vice? Because it didn't happen on a lot of voyages.
No, because it was a matter, it often is just a matter of luck whether it does or not.
Well, isn't
And
luck a fortuity?
It also depends on the amount of moisture in the gloves to start with.
Yes.
Because the moisture content of the gloves can be variable. And it depends on the weather conditions when you load them.
I think it wasn't any suggestion that the gloves were abnormally moist.
Well, not abnormally moist, my lord. I'm not saying anything about abnormal moisture. I mean, you could have a whole range of moisture content of gloves, which is perfectly reasonable.
The difficulty I'm having is in distinguishing a particular change in temperature,
I mean,
which you say isn't a fortuity or peril, it's just an ordinary event, from a change in weather, which
it's not a fortuitous external accident or casualty. I mean, to say that if you go to a ship or an insurer and say, I wish to load gloves in Calcutta in the middle of summer, have them carried by ship to Rotterdam and discharged at the other side of the world where it will be winter, where they will sit in these metal containers for a while. The contemplated carriage is the movement of these objects from India to Rotterdam, where you know there will be temperature gradients in the normal course of events.
I mean, the difficulty is in distinguishing that from carriage from Galveston to Malaysia via South Africa, where you know that there will be changes in the waves and height of the waves.
Except
and
the
so on.
waves are an external fortuitous event, whereas merely changes in the ambient temperature are not. For these purposes, that's what's being looked at. For these purposes, and for other purposes, you might say they're the same, but not for these purposes. Now, we then move on. And what he certainly doesn't say is without the intervention of any fortuitous accident of casualty or perils which might be encountered.
We couldn't show them why they expressly approved this.
Yeah. Well, I know. It's all the same. It's all the same. We then get to Maybat, which we can take quite briefly. The following points, I mean, your lordship has been taken through it, but the following points,
Where do we find it?
volume 2, tab 41,
Yep.
and the following points fall to be made. As we say, it lays down the rule that if the weather is ordinary, which simply means not extraordinary and therefore includes weather at the worst end of any contemplated scale, the loss must be inherent vice if the cargo is unable to withstand that. Note, and this is very important, that there was no argument about the law in that case. This is not a reasoned decision where Mr. Justice Morbick had a chance to listen to the competing arguments which your lordships have heard. It was accepted by Mr. Stewart that severe weather conditions, as long as not abnormal or extraordinary, excluded a loss by perils of the sea and mandated a loss by inherent vice. So,
Where do we find that?
the point was, let me just find it now. Paragraph 26 of the judgment, page 615, right-hand column. Where you see that what Mr. Stewart was arguing, and arguing only, was that the conditions were extraordinary. And if you go back to paragraph 21, the previous page, bottom of the left-hand column, it was common ground that the immediate cause of the damage to the transformer in the present case was the violent movement of the vessel due to actions of wind and sea. These in themselves certainly events of fortuitous nature, and they were external to the cargo, but were they the real cause of the loss? The action of the wind and waves is, of course, an inevitable incident of any voyage, and is therefore a hazard to which all goods carried by sea are necessarily exposed. Goods tendered for shipment must therefore be capable of withstanding the force they can ordinarily be expected to encounter in the course of voyage, and these may vary greatly, etc. Conditions encountered by the vessel were more severe than can reasonably have been expected. It is likely the loss will have been caused by perils of the sea, though even then there might be evidence that the goods would have suffered the same degree of damage under normal conditions. If, however, the conditions encountered by the vessel were no more severe than could reasonably be expected, the conclusion must be that the real cause of the loss was the inherent inability of the goods to withstand the ordinary incidents of the voyage. Now, Mr. Stewart never, as far as I can tell, argued against that. What he simply confined himself to doing was arguing that these conditions were extraordinary, and they were extraordinary because they continued for a long period of time. Although the force wasn't so bad, they lasted for longer than was to be expected, and he lost on that. The only two cases mentioned, the only three cases, were British and Foreign Machine and Gore, Norton and Harding, and Sawyer and Monk. And as far as one could tell, from looking at Mr. Justice Morbick's judgment, it was therefore effectively conceded that what was an issue in that case was whether or not the weather was extraordinary. Now, that being the case, it must follow that the which might persuasive value of this authority is not very high. None of the cases that we have been looking at were cited. Some of them would have, we said, all the cases which we looked at would have been analysed differently. And we looked at various cases, we say, which would have been decided differently if Mayban were right. And I take your lordship immediately to a good one, which is Canada Rice Mills against Union Marine. Volume 1, at tab 17. Now, your lordship, remember the Canada Rice Mills case. This is the case in which rice was being carried, and because the vessel encountered weather, the crew quite properly closed the ventilator hatches, the ventilator openings, to prevent seawater entering and damaging the rice. As a consequence of the ventilator openings being closed, the rice suffered damage through internal heating. And the question was whether or not that was a loss of the rice under the cargo policy of perils of the sea. And the Judicial Committee held that it was. Now, in my respectful submission, if my all you need to, you get the facts in the head note and you get the answer. We don't need to really go through the judgment, because the argument was, well, it's not perils of the sea because none of the sea got near it. And the Judicial Committee said, no, if you take precautionary measures to prevent a peril of the sea affecting the cargo, then any loss to the cargo, damage to the cargo, is by peril of the sea. Now, the rice was susceptible to heating as a result of lack of ventilation. If it were carried normally, if it were carried pursuant to the normal expected incidence of a rice-carrying voyage, it would be carried in ventilated holds. And in ventilated holds, it would not heat. But if you close the ventilation because of the bad weather, and it then heats, it is a predictable consequence, therefore, of bad weather that the rice may heat. The rice is susceptible to heating if it's in an unventilated space. It is a predictable consequence of the expected voyage that you may encounter weather which requires you to close the ventilators. It is therefore a predictable consequence of carrying rice that you may get internal heating because of a need to close the ventilators because of an external peril. Now, on my friend's analysis, that would be a loss by inherent vice. The answer is no, it's a loss by perils of the sea.
I don't think we're going to follow this case in one respect, Mr. Pollen. I see that although the argument finished exactly 70 years ago, judgment was given
on the spot.
In the vacation on the 24th of September.
And you see at page 67 in the judgment, there was nothing abnormal about the weather. If you go down some 6 lines, 8 lines on the bottom, where they say the other question of the cause of the cause approximate can be considered separately. The view of Justice of Appeal Sloan seems to be that there was no peril of the sea because, in his opinion, the weather encountered was normal and such as to be normally expected on a voyage of that character. There was no weather bad enough to endanger the safety of the ship if the ventilators had not been closed. And then you go and say those are not the true tests. Well, that just, it tells you have perfectly normal weather, leads to closing of the hatches, leads to heating, not inherent vice. Although, on my friend's case, as I say again, he would suggest that this cargo was not fitted, this rice cargo was not fitted to withstand the ordinary incidents of this voyage, i.e. the predictable closing of the hatches. Now, that takes one through, I think, most of the inherent vice cases. I just wanted to draw your lordship's attention, if I may, to the albacora, which is in volume 1 at tab 4, because that again gives you a perfectly good definition of inherent vice in the speech of Lord Reed. The albacora, my lord, was a carriage of goods by sea case. It was a case of damage to wet salted fish, which I think turned pink, or something of that nature. But what is useful is on page 59, in the speech of Lord Reed, the left-hand column, you have Lord Reed approving the words of Lord Clyde, the Lord President, in the court below, where he is dealing with Article 4, Rule 2M, that being the exception of inherent vice in the Hague Rules, where Lord Clyde says, Article 4, Rule 2M is, in my opinion, intended to give effect to the well-settled rule in our law, that if an article is unfitted owing to some inherent defect or vice for the voyage which is provided for in the contract, then the carrier may escape liability when damage results from the activities of that inherent vice during the voyage. It follows that whether there is an inherent defect or vice must depend on the kind of transit required by the contract. If this contract had required refrigeration, there would have been no inherent vice. But as it did not, there was inherent vice because the goods could not stand the treatment which the contract authorized or required. Now that, in our respectful submission, is entirely concentrating on the normal incidents of the voyage, the normal incidents of the transit, as requiring you to look at what type of carriage the contract requires, not what is going to happen during the course of that carriage, but how are the goods going to be carried. So what this is doing is intermarrying the issue of the behavior of the goods with the way they are going to be carried or treated as part of the carriage. And you can see why that is relevant and important for an issue of inherent vice, and has nothing to do with the fortuitous externality of whether you meet weather en route. Now, apart from that, the albacora the only other authority perhaps I would draw your attention to before leaving inherent vice is Bradley Federal Steam Navigation Company. Bradley against the Federal Steam Navigation Company, which, my lords, is in tab 24 in volume 2. This is this case about apples. It's the carriage of apples. It's not an insurance case. But again, it's useful for simply looking at how the matter is put on page 400 in the left-hand side. It's a case where there was a great deal of argument about what it was that had caused the apples to turn brown and decay, and the question whether it was some external cause which had affected the apples or simply their natural behavior. And there was a lot of evidence about the amount of carbon dioxide you needed in the atmosphere to do it, and so on. But all I wanted to read to your lordships was the bottom paragraph on the left-hand column. The other way is to say that the inherent quality referred to is not said to be an inherent bad quality, and the words are resulting from, not solely resulting from. The nature of the apples which were damaged, whether they were simply weaker than their neighbours or had some idiosyncrasy, was such that they could not stand the voyage. They decayed not because of the ship or of the sea or of the route, but because they were apples which were not fit to make the voyage in an ordinary way. So he is there drawing a clear distinction between the situation where, because of the sea, you have some external factor which affects the apples, when it's not inherent vice, and in case of inherent vice, when it is something which is independent of those external factors.
So where was that? Which page?
Sorry, my lord?
Bottom left of which page?
400.
400.
Oh, yes.
It's the last full
Yes,
paragraph
yes, thank you.
before the appeal is to be dismissed. But it is rather important to say they decayed not because of the ship or of the sea or of the route, but because they were apples which were not fit to make the voyage in an ordinary way. And so you see, the use of the word ordinary there has got nothing to do with predictable sea states. It's the ordinary way in which they will be carried, stored, stowed, ventilated or not. Now, my lords, can I move then towards the last important section, although we've dealt with some of which is the hull cases, because we do say that the hull cases demonstrate that we are right in this sense, that if my friend is right, they had to be argued and decided differently. Now, we rely on them this way. Mr. G says that unfitness to meet expected conditions is inherent vice. Unseaworthiness equals inherent vice. And that is true for a vessel as well as cargo. And he says, quite rightly as we say, that inherent vice and perils of sea occupy different terrains. Now, if that is so, many of my learned friends' arguments on the hull cases, that they all are to be explained away as cases on causation, falls by the wayside. Because if he's right that inherent vice equals unseaworthiness, and that occupies a different terrain from perils of the sea, then you don't get two cause cases, you get a one cause case, and even if your lordships think that that is too extreme a view, one would expect to see the point being raised and argued somewhere, at least touched on. Now, if he is right, though, and we agree that his approach to causation is right, every time a vessel is lost by unseaworthiness, in the sense that it met a peril of the sea which it was not fit to withstand, there's no question of finding a loss of perils by the sea, or even a contributing cause. It's inherent vice of the vessel, which is the primary cause of the loss. And that should be identified as the primary cause of the loss. So in all cases where, the argument would go where an unseaworthy vessel has been lost as a result of meeting a peril, the automatic outcome, once it was established that the vessel was unseaworthy, and but for that unseaworthiness she wouldn't have been lost, is that the insurer had to win on the basis that the only relevant peril was inherent vice. Now, you would expect to see that argued and upheld if my learned friend was right that unseaworthiness equals inherent vice. But no case, in fact, goes that way. In fact, it's very difficult to find it being suggested. What does happen, and this is important, is that a distinction is drawn between debility, which is inherent vice, where the loss is attributed, in fact, solely to unseaworthiness because the vessel can't even withstand a mill pond and is therefore outside the cover, and the ordinary case of unseaworthiness, which is less than debility, where the loss is treated as a loss by perils of the sea. And it's very important to keep that distinction in mind. Your lordships will remember it is taken by Mr. Justice Mustle, as he was, in the Miss J.J., where he carefully distinguishes between debility and unseaworthiness. And he was relying on all these cases to do that. Now, the starting point is Fawkes and Sarsfield, which is the additional authorities, number 2. I've got mine. I'd rather have mine because It's marked. Additional authorities, tab 2. Now, it's not clear from the case, but this was in fact a case of debility. My learned friend refers to it as a case of unseaworthiness. It is in fact a case of debility. I say it's not clear from the case because you'll read the case as much as you like and you won't find that. But it is treated as a case of debility by Mr. Justice Mustill and by everyone in Dudgeon and Pembroke. And so you will see that at the time it was treated entirely as a case of debility, or as they sometimes put it, wear and tear. Subsequently, all the way down to Mr. Justice Mustill, it was treated as a case of debility. Now, it's a case where what you have is a comparatively standard form of pleading, which talks about the violent effect of wind, waves, the force and violence of the wind and waves and storm, sea and the tempest. You have the use of the word vice to describe what was wrong. You had, as my learned friend said, a number of pleas, but what this case tells you, if I just point to your lordship to the relevant bits, page 194, you have the allegation halfway down the page. By the force and violence of wind, waves, storms, tempests, all other perils and dangers, he became and was leaky and strained, damaged, and was perished and lost.
Danger of perishing.
Then you have the answer that was put in at 196, just before the break, that the necessity for the vessel putting in for repairs were caused by and arose from the said bad and defective condition of the vessel and the exposure of the vessel to the said condition to the usual and ordinary force and violence of the wind and waves on the voyage. Now, we read that and we think the ordinary force and violence of the wind and waves, it was in a storm, not necessarily. Now, you then find, as you see, 197, that the arbitrator finds, as a matter of fact, the pleas were proved as alleged, and the consequence is, in Lord Coleridge's judgment, 203, right-hand page, break towards the bottom. In this case, the underwriters cannot set up any implied warranty of seaworthiness, this being a case in which it was being argued that there was an implied warranty of seaworthiness on a time policy. But then the second point, a different question arises respecting their liability for the expense occasioned by reason of a putting into port. The arbitrator has found the facts, if that's true, without the knowledge of the assured. What are those facts? And then he sets out the first thing, first passage, first paragraph. She would have to go into port because of the defective state of the ship when she sailed. That's just above the first break. And then, one sentence down the next paragraph, the arbitrator fears to find most explicitly that it did not arise from any peril insured against, but from the vice of the subject of the insurance. So what you have to bear in mind when looking at Fawkes is that you've got an arbitrator who's made a fact finding which binds the court. Now, on that state of things, I'm perfectly prepared to accept that you could read it and say, well, maybe that was an ordinary seaworthiness case. But what you do is you then move on to Dudgeon and Pembroke. Authorities won.
But among the pleas was recited on page 204, didn't encounter any more severe weather than is usually and ordinary on such a voyage, or than a ship reasonably fit for the voyage could have encountered without damage or injury. Now you say that's plumb wrong test.
Well, we really don't know. But what matters is how it was then treated, both by counsel and judges, sort of in the very near following cases, because we move on to Dudgeon and Pembroke, which is tab 20 at first instance. And at first instance, before Mr. Justice Blackburn, if your Lordships turn to page 595, Mr. Justice Blackburn, the bottom of the page, the last break, says, 2 cases were on the argument relied on, namely Fawkes and Sarsfield and Merchants. And then he sets out the facts in Fawkes and Sarsfield. And over the page, where if you read it from the bottom, the plea which the arbitrator found to be true in fact was the ship was unseaworthy and met with no extraordinary peril, and that the leakiness arose by and from the said bad and defective condition of the vessel exposed to the usual ordinary force. This seems to be an allegation that the loss was from wear and tear, aggravated by the original bad state of the vessel. And if so, the plea was no doubt good. And you can see that what he is dealing with, thinking about debility, because if you go on that page, he's now talking about the current vessel, the vessel in Dudgeon and Pembroke. 4 lines from the bottom, he says, was the leak from which the vessel foundered attributable to injury and violence from without, or from weakness from within? For that, if it was not attributable to perils of the seas, that is, as he explained, the violent action of the elements from without, or any other casualty involved in the perils of the seas, the jury could come to no other conclusion than that it was due to an inherent infirmity of the ship itself. On this direction, the jury found for the defendants. The verdict was entered for the defendants both on the plea denying seaworthiness and that denying losses by perils of sea, and the Court of Companies refused a rule for a new trial, holding the direction unacceptable. And we quite agree that the direction was unacceptable. For if the vessel was so weak as to give way from the mere pressure of water on her port, without anything more, the proximate cause of the loss was that weakness. So that is a case of debility, and picked up by Mr. Justice Mustard and Miss J.J. and so described. So this was a case, as I say, in which, and your Lordship may remember from when my friend read it to your Lordship, that at the trial Mr. Justice Blackburn had posed a series of questions which are all set out on 591. And what had happened is that the jury hadn't answered some of the questions, one of which was the vessel seaworthy when she started? And if not, was that unseaworthiness the cause of the loss? But nevertheless, what happened was that Mr. Justice Blackburn entered a judgment for the plaintiff and allowed a rule to be applied for that to be discharged, and that took us to the next stage.
You said that...
So not Mr. Justice, Mr. Blackburn discharged the rule, I beg your Lordship's pardon.
You said that the judge was dealing on the bottom of page 596 with the case of Dudgeon Pembroke itself. I'm not sure he was.
I don't think so, my lord. I think he's talking about merchants trading.
I think so,
Lordship's
yes.
quite right. He's talking about merchants trading, not this case. But the major issue being argued in Dudgeon and Pembroke was there a warranty of seaworthiness on a time policy, to which the answer was no. Then the question was, what caused the loss? And you'd had a trial before you'd had a trial, and then it came before Mr. Justice Blackburn and Mr. Justice Quain on the question of whether to discharge or affirm the rule. And this was the hearing, effectively, therefore, the divisional court, there's 2, as to what should happen. Now, if unseaworthiness was inherent vice, then that case would have been answered differently. Now, it goes on appeal to the Court of Exchequer Chamber, and that's in Additional Authorities, tab 2. Tab 1, I beg your pardon, tab 1. And what we would say, so before we go, Mr. Justice Blackburn clearly seems to indicate that if external violence causes a loss by reason of unseaworthiness, That is perils of the sea. If, however, the condition of the vessel is such that no external violence is necessary and it just gives way ordinarily, stability, then that amounts to inherent vice. Now it goes to the Exchequer Chamber, as I say, the additional authorities, and there were 6 judges, my lord, who split 2, 2 and 2. For reasons which are not clear to me at all, 2 who seem to have decided it in favour of the plaintiff, nevertheless sent it back for a rehearing. There were 2 dissentients and 2 others. Now, the vessel was the argument at
Sorry,
page-
where is this in the bundle?
Sorry, my lord, tab 1, additional authorities.
Oh, sorry, yes, thank you. Yeah.
Now, what you ought to do is look at the argument of Mr. Butt at page 104. Because you see at the first break in the page, he says, secondly, the judge was wrong in entering a verdict for the plaintiffs on the 6th issue. A contract of marine insurance is a contract of indemnity, and even assuming that there's no warranty in a time policy that a ship is seaworthy, yet if the assured sends the ship to sea in an unseaworthy state, and she is thereby lost, he is damnified by his own wrong, and cannot recover on the policy. The jury have found that the plaintiffs did not know that the ship was unseaworthy when she started on her voyage, but knowledge is immaterial if in fact she was unseaworthy. So he's now seeking to get round the no knowledge point by in effect saying that an unseaworthy ship is the equivalent of the loss of an unseaworthy ship is the equivalent of a self-induced loss. And as your lordships will remember, that concept was familiar from the case of the effervescing hay, Dubois, that is the basis of inherent vice. So he is putting the point, unseaworthiness itself means that you can't recover. And then if you turn the page, he refers to Fawkes and Sarsfield. And here is Mr. Butt for the plaintiffs saying the loss arose from wear and tear. In other words, a debility case. He's not saying it was an unseaworthiness case. And then going down, thirdly, there is no finding by the jury of a loss by perils insured against. The judge ought not to have decided this question and ought not to have entered the verdict for the plaintiffs on the 3rd issue. The vessel was lost not by the perils insured against, but by her own inherent vice. When an underwriter undertakes an insurance, he doesn't insure against the inherent vice of the thing insured. For instance, he would not be liable for an insurance on a cargo of fruit put on board in a defective state, and which arise destination, or so on insurance of hides shipped in bad condition, which becoming putrid were thrown overboard, the loss being occasioned by the inherent vice of the thing insured. The efficient and moving cause of the loss was the unseaworthiness of the vessel. And he refers to Philip. So his case is very clearly put. Really the case my friend is putting. Unseaworthiness is inherent vice. And that is the effective cause, and that means you lose. Now, he lost. Now, if you look at 114, you can see that this state of this argument was perfectly well understood. Because at the bottom, right-hand, page 114, at the last break in the page, about 8 lines up, in the judgment of Mr. Justice Brett, he sets out the arguments. So he summarizes the arguments that were put. The case was elaborately argued, it was contended for the defendant, that the moving and efficient cause of the loss of the ship was her unseaworthiness, which existed when she first left port, continued until she was lost. Consequently, could not properly be said the ship was lost by punishment. A loss occasioned by unseaworthiness, not arising after the attaching of the policy, must be treated, it was said, as a loss resulting from the inherent vice of the ship. And in either case, the verdict ought to have been entered for the defendant on the 3rd issue. If the loss could be treated prima facie as a loss by a peril insured against, yet a loss arising by such unseaworthiness must be treated as arising from a wrongful act of the assured. And then at the break in the page, he sets out the plaintiff's argument, the other side's argument. And if you go down about 10 lines to where it says, if a loss is caused solely by unseaworthiness existing before or at the time of the policy attaches, it is no doubt a loss from the inherent vice of the ship and is not covered under either form of policy. But if it is a loss caused by a peril of the sea, although caused by the unseaworthiness of the ship existing at the commencement and continuing, it is a loss proximately caused by a peril of the sea. So that's the distinction between debility and unseaworthiness. If it's a loss solely caused by unseaworthiness, the ship was so unseaworthy that it couldn't survive any form of sea, then it's inherent vice. Otherwise, it's not. Now, that's the argument. And you can see well, then he goes on to say, he sets out the questions, and I think one can move on. Well, you can say, well, what you can say is you can see that the battle is joined there with one side saying inherent vice, the only relevant cause, and the other saying, no, it's perils of the sea. Mr. Justice Brett adopted that distinction at page 119, where he says, if the loss, just at the top of the first break, if the loss be solely and immediately caused by unseaworthiness, which existed at the commencement of the risk and continued till the loss, without the happening of any peril described in the policy, in other words, no winds, no waves, nothing, then the underwriter isn't liable because the ship has perished by her own inherent vice. There is in such a case but one cause. There is therefore no opportunity for the applicant of the doctrine causa proxima, which implies the existence of two causes. But if the ship is proximately lost by a peril described in the policy, though the unseaworthiness existing from the beginning is also a cause, there arises the question of whether the underwriter is liable. And he says, yes, he is. So he has drawn that distinction, and he defines or confines inherent vice to the case of debility. Now, then and you see that being carried over on page 120. And if you look at the bottom of page 120, where he says the jury negative knowledge, there was therefore, in my opinion, nothing wrongful in the conduct of the assured. Then the underwriters had no defence. The loss was not the immediate consequence solely of the unseaworthiness. The ship was not lost through her own inherent vice. Now, Mr. Justice Coleridge took a slightly different line. He said there were two concurrent perils, page 127 and 128. You see on page 128 that the break may be said with truth that in this case there was evidence of two concurrent perils to which the ship was subject on her voyage, one a peril insured against the extraordinary and unforeseen action of the sea, the other a peril not insured against the inherent vice of the ship herself. Now, the case then went to the House of Lords.
You've cited so far a dissenting judgment and one of the concurring pair.
Well, it's difficult to say what is dissenting and what is...
I think that I thought it was fairly clear that Barons Brett and Amphlett were dissenting because they wanted to uphold.
What they didn't want there to be a retrial.
Yes, but the other two.
Well, Lord Coleridge and Grove thought that it should go back.
And so did Cleasby and Pollock.
And Cleasby and Pollock, but they did it. It's very difficult to work out the grounds because they said the rule to be absolutely new on the ground that where the ship is in this case, and it has the end as in intended for a voyage, and the time Pollock is made, the assured is under an obligation to have the vessel seaworthy at the commencement of the voyage. So they were out on a limb by saying that there was an implied warranty of seaworthiness.
Well, not really. I think I thought they were saying that
the fact of unseaworthiness, if it's proved to cause the loss, look at page 110, they say which unseaworthiness really causes the loss, about 10 lines from the bottom, is a fact the consequences of which are imputable to the assured and to be borne by him and not by the underwriters. And so you get the sixth plea, which is the plea of inherent vice. I think you're right, I mean, in moving on, because this just sets the background to the House of Lords,
But
which...
what is more important from our point of view is that you have here battle being joined as to what is or not inherent vice. And that's what matters. What you still have a certain amount of debate about is the extent to which seaworthiness, which is not inherent vice, is going to be a defence. And it's ultimately the House of Lords, Law Penzance, which settles that issue for English law, as it turns out, for all time. Because you then move on to tab 21 in Authorities Bundle 1, which is the House of Lords, where, as my learned friend says, Lord Penzance participated, having argued Fawkes and Sarsfield, and where Lord Blackburn, having decided Dudgeon and Pembroke in an earlier stage, now approved his own previous approach, having risen in the interim. Now, if you look, if you would again, at Mr. Butt's argument, 289, to see what was being argued about, bottom of 289, left hand, if the ship was unseaworthy and the plaintiff sent it to sea in that condition, and the loss was occasioned thereby, the plea was good to the action, the averment of scienter was unnecessary. If the ship went to sea without being fit to encounter the ordinary risks of going to sea, not the extraordinary risks of storms, for the consequences of which the insurer alone made himself answerable, the assured could not recover. A policy of insurance was only a contract against risks which could not be foreseen or by ordinary care provided against. If a vessel could not sail over a smooth sea without making water at such a rate as to threaten danger, such a vessel was not fit to be set to sea and was not a proper subject of insurance. Now, the way that is put is all rather makes one wonder whether he isn't actually talking simply about debility again, because it's rather odd to say you only insure against extraordinary risks if you're thinking of the fact that storms can be foreseen. And he picks it up under Thompson and Hopper, where he talks about in a condition not fit to encounter ordinary sea risks. And if that is right, that he's really talking about debility and seeking to say this was a case of debility, then ordinary sea risk doesn't mean foreseeable risks on a voyage, but simply the inherent inevitable risks that you get from going to sea, even in a mill pond. Now, Lord Penzance, the crucial bit of Lord Penzance is page 296. Where if you start at the bottom of 295, the break, it will at once occur to your lordships, upon the raising of such a question, which is simply a question of ordinary seaworthiness, that it applies as much and as fully to a voyage policy as a time policy. If a loss proximately caused by the sea, but more remotely and substantially brought about by the condition of the ship, is a loss for which underwriters are not liable, then quite independently of the warranty of seaworthiness, which applies only at the commencement of the risk, the underwriters would be at liberty in every case of a voyage policy to raise and litigate the question whether, at the time the loss happened, the vessel was, by reason of any insufficiency at the time of last leaving a port where it might have been repaired, unable to meet the perils of the sea and was lost by reason of that inability. If such be the law, the underwriters have been signally supine in availing themselves of it. For there's no case that I'm aware of, except those which I've read, in which anything like such a defence as this has been set up. Now, what he's effectively saying is, if the inherent vice argument that my friend is now running is right, well, the underwriters have been signally supine ever raising this, because what he is saying is, it is remarkable that hitherto no one has said, if the vessel was in fact unseaworthy, it wasn't a loss by perils of the sea, it was a loss by inherent vice. So if the rule was that unseaworthiness not being debilitative trumped everything because it was inherent vice, then that passage in Lord Penzance's speech there makes absolutely no sense. It would always be a benefit of the underwriters to prove that the vessel was unable to withstand the ordinary perils, because then they could run a case of inherent vice. Now, my learned very well, but it might be two causes. An inherent vice might not have been excluded, but just not covered. But that isn't the way things work, because if there's a possibility of persuading the court that inherent vice was the cause, then you'd run it. Might not win on every occasion, but you wouldn't just fail to run the issue at all. Now, my lord, so what your lordship has to understand in our respectful submission is that, yes, and he refers to Fawkes and Sarsfield on that same page, and your lordship will see it was a case where he dismisses the case of partial loss, where there was a finding by the underwriters, by the arbitrators. Now, I hope, without having taken it too quickly, that demonstrates that that particular aspect is really a little bit more complicated than one might think. And then you go through from there, from dudgeon, the case, we would say, is established all the way down through the Marine Insurance Act, through those cases which I took your lordship of Frangus and the Gloria, until we get to Miss JJ, where, with great respect to my learned friend, Mr. Justice Mustle's summation of the law was, in our respectful submission, absolutely spot on. Now, and as you can see, the point really doesn't arise again very much. You've got it being tried in Frangos and then never again. Now, I think that deals with the Hull cases, my lord, as much as I wish to do so. Yeah. Says it's a yes. Yes, I'll just make good my point that Mr. Justice Mustill treated it as a debility case. If you want, give me 1 minute to get back to
43.
that. Tab 43, my lord, in bundle 2. Page 272 in the bundle. Your lordships will see it on page 271, the bottom left-hand, in the right-hand column. Mr. Justice Mustle's referred to Dudgeon and Pembroke, and then down through Frangos, and then he comes to debility at the top of the left-hand column in the page 272. Where a ship sinks through its own inherent weakness, there is no loss recoverable. It is not enough for this purpose the vessel is unseaworthy, the loss must be disassociated from any peril of wind or water, even if these form the immediate context of the loss and constitute the immediate agency, for example, the percolation of water through an existing flaw in the hull, by which the loss takes place. As Lord Buckmaster said in Grant Smith, the policy is not a guarantee that the ship will float. And then he says, see Fawkes and Sarsfield in relation to the first loss. The first loss was the one that we were dealing with. That's when she had to put in for repairs. She subsequently sank, and that was a loss which was paid. And this distinction between unseaworthiness and debility is reflected again in the judgment of Lord Justice Slade in the Court of Appeal, which your lordships find in the next tab.
There was some discussion in Mr. G's submissions about Mr. Justice Mustill's division of the weather into three classes of weather.
Yes.
Now, what, if any, significance does that have, and to what question?
What significance?
Well, on the left hand here, he has...
Oh, yes, in page 271.
Yeah, the abnormally bad weather, the adverse weather, and the favourable weather.
Well, he's got... he is using the weather conditions, I think, to deal in particular with debility. I mean, he's
Debility is what happens where a ship falls to bits in favourable weather.
In very favourable weather. I mean, at the end of the day, if you look at his analysis, as long as it isn't right at the bottom end, perfect weather, all of the rest is perils of the sea. I mean, it's a very helpful analysis.
But even favourable weather.
Well, even favourable weather, because you see, favourable weather is within the range that well, yes, I don't know. Maybe favourable weather wouldn't be. I mean, favourable weather.
It's very, I thought it was very
Better
interesting,
than
but if you say to yourself, so what, after all this? I wasn't sure what.
Well, no, it's very useful, but I'm not sure that it necessarily is something that I have to deal with in this case.
Right.
At the end of Lord Justice Slade, 41, page 41 in the next tab, left-hand column, where he says, the last full paragraph, finally I wish to stress that the conditions of the yacht in the present case was not one of debility. If at the start of a voyage a vessel is in such a state of general debility that the ordinary action of wind and waves in any type of sea is bound to cause her damage, and such action duly causes her damage, common sense may dictate that the condition of the vessel, rather than the action of the wind and waves, shall be treated as the sole proximate cause of the damage. That I understand to be the effect of the charge at sea, for example, Fawkes and Sarsfield. So he is treating it the same way. Now, I would just mention in passing the Xantho.
Isn't Miss JJ, mustn't you say that the Court of Appeal is wrong at page 37 in Lord Justice Lawton's judgment, and probably also at page 41 in Lord Justice Christopher Slade's judgment? Because, what they say there was essentially, just taking 37.
So, could your lordship give me the reference again?
Sorry, it's tab 44.
No, they're pages.
Page 37.
37.
And the other page was the last page, page 41. But 37, halfway down the left, end of the middle paragraph, he says, I don't accept that he had judged that the unseaworthiness of the cruiser was irrelevant. If he had done so, this court would have had to decide on the evidence whether the adverse sea was a proximate cause of the loss. And then in the middle of the right-hand column, the last paragraph of his judgment, what has to be decided is whether on the evidence the unseaworthiness due to design defects was such a dominant cause that a loss caused by adverse sea could not fairly and on common sense principles be considered a proximate cause at all. In my judgment, the evidence didn't establish anything of that kind. What it did establish was that but for a combination of unseaworthiness due to design defects, the loss would not have sustained. Both were proximate causes. And similarly, Little Justice Christopher Slade, right at the end, speaks of equal efficiency in the sixth line in bringing about the damage. So, they're accepting a completely different hypothesis to the one you've advanced, which is somehow you have concurrent causes, whereas you've argued strongly that perils of the sea actually excludes inherent vice and vice versa.
And vice versa. Well, they were saying that in this case. As regards the first passage, I would treat on page 37. Is this Lord Justice Waller, Lord Justice Lawton?
Yes.
Lord Justice Lawton, as effectively looking at a case of debility, because what he's saying is whether on the evidence the unseaworthiness was such a dominant cause. Now, if you've got unseaworthiness, and because of unseaworthiness, the vessel can't withstand the ordinary perils of the sea. you're not going to say that the seaworthiness was such a dominant cause, because after all, normally, if you're looking for two causes in those sense, you say they are of equal efficacy or efficiency. If you're saying it was such a dominant cause, that seems, in my respectful submission, to lead one to the view that what he has in mind was the unseaworthiness, as in Fawkes and Sarsfield or any of those cases, so debilitated that in fact you don't really worry about the peril of the sea, because it was going to fail without the intervention of a peril of the sea in any event. Now, can I mention the Xantho, just briefly? It's 1887, and it appears in volume 3 at page 63, tab 63, I beg your lordship's pardon. With only two short points I want to make in relation to the Xantho. One, I think your lordship probably well aware of. In the speech of Lord Herschel at page 509, it was made clear that the concept of perils of the sea encompasses ordinary as well as extraordinary weather. And I merely mention that because...
Sorry, the reference again, authorities
it's
3.
Volume 3 of the authorities, my lord, tab 63.
Thank you.
And it's 1887, and what it demonstrates, at least from 1887 onwards, there can be no doubt in anyone's mind that perils of the sea didn't mean extraordinary things. In page 509, and that is made quite clear. And that's what the Xantho is usually known for. But the other point which is worth having in mind is at page 510.
He defines casualty as something which could not be foreseen as one of the necessary incidents of the voyage. That's another definition.
Page 510, he's dealing, your lordships will see at the break at the top of the page, that in a case of marine policy, causa proxima alone is considered. If what immediately caused the loss was a peril of the sea, it matters not how it was induced, even if it were by the negligence of those navigating. It is equally clear that in a case of a bill of lading, you may sometimes look behind the immediate cause, and the shipowner is not protected by the exception of perils of the sea in every case in which he would be entitled to recover on his policy on the ground that there has been a loss by such perils. Now, all he is pointing out there, at the end of the day, is that although you may define perils of the sea similarly for marine insurance and cargo case and carriage cases, what you may have to do is apply them differently because of the different purposes for which the perils of the sea concept comes into operation. And that just picks up the point I made to your lordship earlier about inherent vice and its role in carriage cases or in marine insurance cases. Now, my lord, can I touch very briefly on the issue of a new trial? The only case the underwriters have ever advanced is failure by metal fatigue in a predictable sea equals inherent vice, QED. We have always said that that was wrong as a matter of law. If that defense fails because this court holds that as a matter of law it's not enough, it is difficult to see on what basis they are now asking for a new trial to run some form of different defense which they never raised at trial, whether as an alternative or otherwise. The plaintiff's case always was that Mr. Justice Mustle's analysis was correct, i.e., as long as it wasn't debility or wear and tear, it was a loss by perils of the sea, and inherent vice simply didn't come into play. And in support of that, it was argued that Mayban was wrong and inherent vice did not extend to uncargo worthiness. Leave aside the complication at the trial that an alternative case was being run as well. There were inadequate repairs done at Cape Town which could have put things right. That lost on the facts. Now, that has been our case all the way up and remains our case here. The other side's case remains what it always was, no inherent vice, and that's it. So it's difficult in our perspective to see exactly how matters have gone astray so as to leave my friend with a feeling of any form of grievance. Insofar as Lord Justice Waller produced an answer which differs from that which I am seeking, that is because that's what he decided to do. It wasn't a case that we ran. My submission is that Mr. Justice Waller has not done that, but has properly understood what Mr. Justice Waller is saying when he talks about whether that is bound to occur. He is picking up the debility point. And what he is effectively saying, although with the greatest respect to Lord Justice Waller, perhaps not expressed as clearly as it might be.
This is paragraph 62, is it?
Yes. What he is saying is, he's picking up the debility bound to occur point. Whether damage, even the question becomes, was it cause an inability to withstand the ordinary incidents of the voyage? The answer can be found reasonably foreseeable as the ordinary incidents of the voyage. So he's saying, assuming that as a matter of formulation, the test that you put out is, can it withstand the ordinary incident of the voyage? Ordinary incidents in that context does not mean what you would foresee might happen on the voyage in terms of weather. In other words, he's adopting, perhaps, I would hope, the argument that was being put by Ms. Blanchard to the effect that when you look at all those cases we just looked at, which refer to inherent vices involving survival, or at least its behavior in the light of the ordinary incidents of the voyage, that is to be interpreted the way we have suggested, and not the way my learned friend suggests. So what he is then saying is, the answer cannot be found reasonably foreseeable, but by reference to wind or wave, which would be the common incident, would be bound to occur as the ordinary incidents of any normal voyage of type being undertaken. And he goes a little bit far, because he wouldn't just say normal. What he means is the minimum that you would be expected to encounter by just ordinarily sailing. Now, if he goes any further than that, we say he's wrong. If it goes no further than that, well then, he has effectively, but in rather odd language, adopted our argument. But this was not an argument, if that is the case, that Miss Blanchard was putting below. And we simply do not know what would have to be investigated or applied on the basis of this test which Lord Justice Waller, on that hypothesis, has adopted. It is a little bit of a mystery. Not at all easy, I'm afraid, to decide exactly what test he had in mind.
Well, you say
that
we
makes
should
sense.
interpret it as meaning kind of transit, effectively.
Yeah, but you've got my argument. That's what we say. That's what we say. Your Lordship should decide. Shouldn't go any further than that. Now, can I just then make one or two miscellaneous points, which won't take me more than a minute or so, I think, and then my friend has his reply. Firstly, my learned friend Mr. G was pressed from time to time by your Lordships for examples of contributory causes, inherent vice and perils of the sea, as giving rise to a claim. And we submit that the way he did or did not deal with that does rather illustrate the oddity of the approach that he is adopting. He said at one stage, if there was a 1 in 1,000 chance of the vessel or the rig not arriving successfully, there would be no contributory, there would be no dual causes. If it was a 1 in 5, there possibly would be contributory causes or contributing causes. You could possibly come to a conclusion there was perils of the sea and inherent vice. Now, one simply asks, how does this work? Where and on what basis do you draw the line? And in particular, what is the principal basis on which one distinguishes between a loss by inherent vice and a loss by perils of the sea, when the vessel was unseaworthy to some degree of risk? Because if you're going to draw a distinction, it's not going to be all one way or all the other for all cases. Then you've got to be able to formulate some form of realistic rule, which, as a matter of principle, tells you how you distinguish between the perils of the sea case and the inherent vice case. Because what my friend seemed to be accepting, that at one end of the scale you always had to say it was inherent vice, at the other end of the scale you might always say it was perils of the sea, and somewhere in the middle you might say one or the other or both. But in all cases, there would be, on his case, a degree of uncargo worthiness which had raised or posed some degree of risk. Now, where on this scale between 0 and 100 as to the degree of uncargo worthiness risk do you draw the line? And in this respect, my Lord Savile, pressed my friend as to what would happen if there was simply a 10% risk, and with great respect, that was never answered. The other small point I would make is the defective packing example he gave when there was extraordinary weather and packing which was inadequate for ordinary weather, and he suggested that would produce two causes. Well, it can't, because if the packing was adequate, as on his hypothesis it was for extraordinary weather, its insufficiency if it was inadequate for extraordinary weather, its insufficiency for lesser weather must be irrelevant. The truth of the matter is that it's impossible, we would say, to give a satisfactory two-cause example on my learned friend's analysis of the meaning of inherent vice. Now, my Lord, that is all I would wish to say to your lordships, unless there's anything I can help your lordships with further.
Thank you very much. Ms. Blanchard.
No, madam.
Yes, Mr. G.
I have a reply, but I think it's going to take a little bit longer than up until 4:15.
Well, it'll be up till 4 o'clock, I'm afraid.
Up to 4
That's the
o'clock.
time we normally rise.
Now, I'm in your lordship's hands about how you'd like to deal with it. I can certainly put part of it in writing. That would
Well,
be...
let's see how we get on, and it may be that if you feel there are other things you wish to add at 4 o'clock, probably the better thing to do is to put them in writing.
Yes, certainly. What I'm going to do is to start with the law, as opposed to Mr. Pollock's factual matters. I will say that just on the meaning of the policy, there's a passage in Lord Diplock's speech in Sawyer and White, which says that when you're dealing with standard form policies like this, they ought to have a standard form meaning, and one shouldn't look at attendant circumstances on the particular contract. You should simply apply the meaning which is on the standard form. But
Well,
second,
I wonder, because that applies a completely different rule to this form of contract than to the way we all look at contracts nowadays.
if we're going to get down that route, we will be saying that there was no pleaded case that we had any particular knowledge in relation to the risks of fatigue. We didn't call our underwriter. We dealt with the case on the pleadings. The judge hasn't made any findings of what knowledge we had. And Mr. Pollock has, in his address to your lordships, made various statements about what must have been our knowledge and so on. But actually, it's not a point that's ever figured in the case. But I'm going to go down the legal cases, if I may, rather than the facts. There's quite a lot that I would want to say to correct what has been said about the facts by my learned friend.
And you must have had certain knowledge. You were insuring a rig with legs going to be carried with 300-foot legs sticking up in the air, exposed to a long voyage with choppy seas and so on. And,
there would have
and
been
you
some
needed a surveyor to look at
Yes.
fatigue risks and that sort of thing.
Yes. I mean, what has happened in this case is that Dentons have been nominated by the other side,
Yes.
approved by us.
Yes.
They've issued a certificate, which you will find at paragraph 22 of Mr. Justice Blair's judgment. And you'll see that that's done purely on a superficial fatigue analysis. Where's the ledger? You can see in that certificate, item 1, the Odin Liberty legs have been the subject of a simplified fatigue analysis. And there was nothing there about any spectral analysis. And what happened was that if we go through to 26, whatever the reason, the necessary calculations must have been done by this stage, because Viking, that's the assured's consultant, was dated the 21st of September. And then it showed the figure of 2.13, which was a wholly different figure from that which was previously. And then Noble Denton had been provided with revision D of the simplistic fatigue analysis dated 20th of September, but they weren't provided with the spectral fatigue analysis of the 21st of September. And that was a mystery. So that certainly one can say, well, people may have contemplated that there were some fatigue problems here, but certainly to say of my clients that we knew anything of the extent of the fatigue problems that in fact were present would be wholly incorrect. And one can see how it developed. Now, Mr. Pollock was asked a question that he didn't give an answer to. And it's an important question.
How did they assess the risk then? Perhaps we don't know.
We don't know, is the answer. There just isn't the evidence.
When did the policy incept?
It attached from when the rig started to be loaded at Galveston.
When was the contract made?
We know when the certificate was issued from the judgment.
20th of July.
An assessment of risk suggests that you realise they were on risk for fatigue problems, so that if they weren't, they wouldn't have anything to assess.
Well, no, because there'd be lots of other risks.
Well, of course,
in relation to this
in that
voyage.
respect, they wouldn't have anything to
The
assess, of
policy
course.
of the
They'd be assessing all the conventional risks of...
And nobody would want to have a casualty on this.
No.
What appears to have been the case is that the consultants were very well aware that there was a possible fatigue problem. Denton would obviously have been aware that there might be one, and their certificate at paragraph 22 refers to the simplified fatigue analysis. But quite clearly, when they issued their certificate on the 23rd of August, they had no idea of the extent of the fatigue problems that in fact were present for these legs. And it's a fair inference that my clients never had any idea of that extent. And then subsequently, Viking, of course...
Well, we can see that they knew there was a risk because by the form of the certificate.
Oh, yes, Denton's did, yes, Noble
No,
Denton.
but I mean, yeah.
But it's one thing to say, oh, well, there may be a fatigue, you've got to do fatigue analysis. You've got to check that it's reasonably fit for the voyage on the basis of the fatigue analysis. It's quite another to say that my clients knew of the extent of the fatigue problems that were in fact present in relation to this
At
transfer.
any rate, the contract was made on the day of the same day as the slip, of the cover notes, which is the 20th of July.
Yes. So that on that basis, there is no basis whatsoever for saying that my clients wrote this risk on the basis that it knew about the extent of fatigue problems that in fact...
Well, I don't think Mr. Pollock was actually
Same.
suggesting your clients did. I mean, his factual matrix argument is that fatigue was a potential problem. I don't think he was suggesting your clients necessarily knew what people were thinking about the extent of the potential problem, but simply that this was a case where fatigue might play a part.
It might be a problem, but of course the rig has to be fit for the contemplated voyage. And nobody's suggesting that my clients wrote this risk otherwise than on the basis that this rig would be fit for the contemplated voyage.
Well, that,
Well, there's no warranty.
with respect, is begging the very question at issue, isn't it?
One's got to look at the words of the contract. And I'm not trying to rewrite the contract. So, let me return to Mr. Pollock's question that was asked, which is, can you claim for the cracks in Cape Town?
I'm so sorry, I couldn't hear that.
Can you claim for the cracks in Cape Town? And the answer to that was no. And it was no for two reasons. Firstly, if you just had ordinary cracks, which were necessarily going to happen during the voyage, they would be banned by ordinary wear and tear. If you had cracks that were a bit worse because of the fortuities of ordinary incidents of the voyage, you couldn't get those because they were cracks that would have developed by reason of inherent vice. They would be purely internal to the item.
No, I didn't say either of those.
I thought Mr. Pollock actually said yes, was his answer.
All right, he says yes.
But you say no.
We say no.
Yeah, I thought he said yes, but it didn't matter because of the deductibles. Is what-
Yes, but the deductible doesn't matter for the purposes of the argument.
Well, I mean, I think you're begging a number of questions there because, I mean, he says it isn't ordinary wear and tear because it's the effect of the seas, and if they're worse, it isn't purely internal because the effect of the seas must have been even worse.
Of course, that's what he says.
That's
what he says, but
yeah.
it's wrong.
Yeah.
And what we say is that it would be excluded because it would be pure inherent vice.
Yeah.
And that's
And-
the question.
Well, I think we.
And when one's looking at inherent vice, Mr. Pollock's argument focuses on the waves. And it starts with the proposition that there's nothing wrong with a piece of steel as a piece of steel, and nothing wrong with a rig at Galveston for use as a rig. But that's the wrong starting point, because inherent vice and nature of the subject matter is about its fitness for the contemplated voyage. And one sees that time and again in the cases. If one goes to Lord Justice Donaldson's judgment, which you've seen, the definition by Lord Sumner, it is in the circumstances in which the item is carried. The Donaldson test, in the circumstances in which they are expected to be carried. And the reason that expected is added is because one's looking at the fitness at the time of the attachment of the risk. And of course, you're looking forward at a point in time. And when one goes to Lord Diplock, it's in the ordinary course of the contemplated voyage.
I mean, your test is the same as the test in section 39(4) of the Marine Insurance Act, isn't it?
Yes. And you cannot divorce inherent vice from the contemplated voyage. That is what you're asking, is the fitness. It's not fitness of hats as hats. It's fitness of hats to travel on the particular voyage. Similarly, Lord Justice Bingham, the passage, there's nothing unusual, nothing untoward. What he's looking at is lack of fitness for the voyage. Was there anything on the voyage which was external and which was unusual or untoward? Because the test is by reference to the ordinary contemplated voyage. Similarly, Nelson, inconsistent with the ordinary incidents of the carriage.
It does all depend, doesn't it, this leg of the argument, if that isn't a pun, on what stamp we put on the phrase the contemplated voyage. Mr. Pollock puts a narrow stamp and he says that all you contemplate is the basic features, the kind of transit, because everything else is looking at it from Galveston's at Galveston in the lap of the gods.
That is true. Professor Bennett, in the article which you asked Mr. Pollock about, if we could just turn that up, it's in Authorities 75, at page 348.
Which volume?
Volume 4, Authority 75, page 348. At the foot of the page, this is after his analysis of Mayban. He
Page,
says,
page.
348.
It's 80, I think. 80.
Sorry,
Oh, sorry.
wrong. You're in Arnold, yes. 80.
I don't think it's 75.
Sorry, no,
It's 80.
It's 80.
80.
Yep.
80.
348.
I'm terribly sorry.
345.
348.
348.
348. Yeah.
You see the foot of the page. The above discussion has focused on the single prolonged period of heavy weather encountered by, and this is the vessel in the Mayban. It may, however, be noted that on the facts of Mayban, it wouldn't have been at all unusual for the transformer to be exposed to several similar, albeit briefer, spells of bad weather, and the damage could have been caused by 2 or 3 such shorter periods. The decision in the case may be justified if such shorter periods of bad weather could be considered so ordinary and natural an incident of the voyage, it would be unusual to complete a voyage without encountering them. An inability to withstand such shorter periods would then qualify as inherent vice, even on the narrower view favoured in the article. So, Professor Bennett, certainly regarding the external forces to the vessel as being something that one takes into account as the ordinary incidents of the contemplated voyage.
Well, he adopts, I mean, it may be sufficient for your purposes, it occurred to me, but he actually adopts an intermediate position between you and Mr. Pollock. This is his habitual risks test.
Yes.
If the goods can't stand habitual risks, that's inherent vice. On the other hand, if the risks aren't habitual but are just reasonably foreseeable, then it's not.
There's this dividing line.
I mean, this is a whole new test, isn't it?
Exactly.
Which nobody has so far advanced.
Nobody has advanced
Including
it.
you, Mr. G, is that right?
No, I haven't advanced it. What I'm saying is, though, is that Mr. Pollock's argument gains no support from Mr. Bennett's article, Professor Bennett's article, which is the article which is the foundation for the Court of Appeal judgment. And
Is it? I thought the Court of Appeal has taken an even more restricted line. The Court of Appeal's line is that unless the risks are inevitable, it's not sufficient if they're they're irrelevant unless they're inevitable.
Yes. All that I'm pointing out is that certainly the argument by Mr. Pollock is to look at certain incidents of the contemplated voyage, but not other incidents. And where is the dividing line? He says, well, the atmosphere within the hold, that would be ordinary incidents. But something that happens outside the ship, even though it may have a very important effect on atmosphere in the hold, apparently that's outside. Why? Where's the logical line? And what's the basis for it? And we say that on the Bennett view, we succeed.
Well, there's a fallback. We should take the Bennett view.
I take it as a fallback.
Oh, so it is part
I
of
don't say it's right.
It's your case in the alternative.
It's my
You
case
see, your
in the
case is
alternative.
it's wrong, but if necessary, we
I'm
should say
quite
it's
happy
right.
to take it in the alternative. Now, I want to say a few words about debility. Debility is referred to in Mr. Justice Mustill's judgment in Miss JJ, and in our submission, what it means is that the vessel is in such a dilapidated state that it sinks through ordinary wear and tear. And you will find that in the Sassoon case, in the Wadsworth case, so let's just see, it's Authority 64, and it's Bundle 3. If one goes to the judgment of Lord Justice Strutton, it was a 50-year-old barge, and he says at the top of page 286, she'd had 50 years of life on the Mersey carrying coal. 50 years is not at all an impossible age for barges. In London, in my experience, there are barges running which are older than 50 years. And then at 286 right-hand column, the learned judge, this is just before the break, the learned judge, as I have said, has found that the cause of the barge sinking was this general debility, the phrase he gets from the Mersey Docks and Harbour Board surveyor. And then at page 287, left-hand column, last paragraph, then comes the question. It's halfway down the page. That being the fact we have to work on, what's the effect of the policy? There were two policies. No appeals are raised on one. There's no appeal insured the steam barge Edith on the ordinary printed form. And it was due to its own inherent weakness, has decided that there's no total loss by perils of the sea. There's no appeal with regard to that. And it's in accordance with the law in Samuel and Dumas that if the effect of entry of seawater into a ship is not in itself a peril of the sea, and in accordance with 55(2)(c), the insurer is not liable for ordinary wear and tear. And then over the page, 289, left-hand column, two views, each of them resulting in some rather odd result. The Act says, unless the policy otherwise provides, the insurer is not liable for ordinary wear and tear. So the Wadsworth case, which is cited in that passage by Mr. Justice Mustill in the Miss JJ, it's in Authorities 43, is by reference to ordinary wear and tear. Remember that it's the passage at page 272, left-hand column. And Mr. Justice Mustill says, where a ship sinks through its own inherent weakness, there's no loss recoverable. It's not enough for this purpose that the vessel is unseaworthy. The loss must be dissociated, etc. And if one looks at the Grant Smith case, I'll give you the reference. It's Authorities 2, tab 30, and it's pages 171 to 172. And it's the passage with there's no warranty that the vessel will float. It's exactly the same point. It's a vessel that sinks through ordinary wear and tear.
I'm not quite sure what we're getting from this.
The point is that...
I didn't think there was any dispute about that.
No.
I thought that's where everybody agreed that's what debility meant.
Good. Well, then, focus is not a debility clause.
That's
Focus is unseaworthiness. And when one goes to Lord Penzance in the House of Lords in Dudgeon and Pembroke, the relevant passages at 295, 296, which you looked at, what he's talking about is supervening unseaworthiness on a time policy. With a voyage policy, you've got a warranty of seaworthiness. That's under the Act, and that was at common law. What you didn't have a warranty of seaworthiness for were the supervening voyages under a time charter or a time policy where there was unseaworthiness where you left the last port. And that's all that Lord Penzance is addressing at 295, 296. And similarly,
The time policy, is there a warranty of the seaworthiness for the first voyage? It's
No.
not, it's a time policy.
No.
There's no warranty at all.
There's no warranty at all. Now, we also need to look and see what's the position about cargo pre-Act, which is the position that came into the Marine Insurance Act. And for that purpose, one needs to go to Coble and Saunders, which is cited in our case at para 22, and it's Authorities Volume 2, 36. Now, this was a decision of the Court of Common Pleas, and the leading judgment was given by Mr. Justice Willis, and he says it's an action upon a policy of insurance on goods to which the defendant has pleaded, this is at page 31, that the said premises so insured as aforesaid weren't seaworthy for the said voyage.
And you're reading from page?
Page 31.
Okay.
halfway down, it's the beginning of Mr. Justice Willis's judgment, that the said premises so insured as aforesaid weren't seaworthy at the time the said ship departed and set sail thereof. To this plea the plaintiff has demurred, and the question is whether the plea furnishes a sufficient answer to the action. I'm of opinion it does not. It might be sufficient to dispose of the matter by saying that the plea is a novelty. It is a novel, not merely with reference to the circumstances, but also in its character and in the principle which it seeks to affirm. Questions of every kind so frequently arise in actions on policy that the ingenuity of counsel would doubtless have furnished one instance. And they say they can't find any instance. It seeks to introduce into the contract of insurance a new implied warranty which is at variance with all principle. As a general rule, the insurer is not liable for damage resulting from peculiar vice or infirmity in the thing which is the subject of insurance. It's upon that footing that the seaworthiness of the ship is held in our law, as well as in that in most commercial countries, to be an implied warranty. It is a sufficient answer to the assured to show the vessel was unseaworthy, without going on to show the damage sustained was the consequence. But in the case of an insurance on goods, it's no answer to say they were in unfit condition to be shipped, unless it's shown that the loss arose from that unfitness. And it's laid down in Smith Commercial Law, Boyd and Dubois, goods be put on board in damaged condition and are in consequence liable to effervesce and generate, by which they're consumed, the underwriters are not liable. Nothing can be more distinct than the rule of insurance law that it's a warranty or condition that the vessel be seaworthy at the time she sets out for her voyage, and then so on. And the point there is that it was argued that there would be a warranty of seaworthiness on goods, and it was rejected. And it was rejected in favour of the causation-based defence of inherent vice. And that is precisely the form in which the Act operates. If one goes through in Authorities 1 to sections 39 and 40, one finds that there is no warranty of fitness of the goods for the survival of the contemplated voyage. But one gets into section 55.
So we're back to the meaning of inherent vice then, really?
Absolutely.
This precedes Dudgeon and Pembroke.
Yes, it does. And it's a case that was never questioned and it was adopted in the Act.
Well, who say that? Do we know that? Has anyone actually looked at the commentaries?
I
Sir
have,
Mackenzie
but
Chalmers.
it's in Chalmers, and it's got all the footnotes to the cases, which are the basis of the various sections.
It's cited somewhere, is it, in Chalmers?
And, of course, it's cited in the Court of Appeal judgment here, and it is the leading case on that point. So we're left then with the argument, well, ordinary incidents of the voyage include some of those, but not all of them. It includes the air in the hold, but not what happens with the seas. And on that, we say that that is wholly inconsistent with the formulas for inherent vice in Sawyer and White, adopted in Notem. Mr. Justice Phillips, at first instance in Notem, cites both the Donaldson formula and the Diplock formula, and he treats them as equivalent, just as he adds the Diplock formula. And you've got the Hatts case, which was cited by Mr. Pollock. Remember that mountain case. Now there, I can just ask you to turn that up. The reference to. It's Authorities 3, tab 66.
Tab
366. This is Mr. Justice Roche.
Sorry, Mr. G, I've lost you. Authorities 3, isn't it? Yeah.
Yes, 66.
Thank you.
Now, in the left-hand column, 180, he says there were lots of sound shipments. And the second reason for rejecting inherent vice is I'm satisfied there having been an instance of mould which was, so far as the investigation went, due to external wetting, but apparently there having been a suggestion it might be due to manufacture, that there had been extreme care taken with regard to the shipment now in question. It suggested it might have been the moist atmosphere. If it was that, I think it wouldn't be a matter which would render the defendants liable. Moist atmosphere is not an accident or peril that is covered. It is more or less a natural test or incident which the goods have to suffer and which the underwriter has not insured against. So he's treating the atmosphere in the hold as being part of the ordinary incidents of the voyage. And that's why inherent vice, in that case, would be available had the goods been unfit on shipment. But they weren't unfit for the contemplated voyage. And so what one gets from all of these cases is this, that if one tries to apply it to the present case, you've got a rig which wasn't fit for the contemplated voyage at Galveston. And that's found as a fact by the judge. It's not fit because it's liable to develop cracks. And it's going to develop those cracks internally. And it's going to do so by virtue of the conditions in which it's carried for the contemplated voyage. Those cracks, sooner or later, are liable to develop to complete failure. It's true that there is a chance, a minute chance, that the cracks won't lead to ultimate failure.
It wouldn't make any difference, but it wasn't a minute chance, though, would it, on your analysis?
Well, the chance is only part of the evidence. The fact that something has a chance of going very wrong in the voyage is very relevant to the question of unfitness at Galveston. And it's also relevant to the causation question, because the more probable a thing is to happen, the more probable it is that when it does happen, it's due to the cause in respect of which you've said that there is a probability.
Well, I follow that. That's not quite an answer to my Lord Clerk's question. I understood, perhaps it's my fault, but the fact that it's almost certain to happen or is likely to happen or is not very likely to happen, or it's only possible that it might happen, plays no part in your argument as to what the meaning of inherent vice is. May well play arguments when you come to try and establish what happened and why it happened.
We say it only goes as part of the evidence for deciding those two critical issues. Those issues are defined by reference to the meaning of inherent vice.
So I think, as I said yesterday, if the case had been different on the facts and when they set off, there was a 10% chance of cracks developing, and if you like, a 5% chance of those cracks propagating, and a 3% chance of them propagating to the degree that the entire legs fell off, and you were able to prove that that was in fact what happened, you would still say inherent vice.
I would say
if I've understood you correctly.
It's unfit because there's a 10% chance. And I would say, what is more, that unfitness is what caused the loss on the evidence. So that the 10% risk would be, in my respectful submission, sufficient for a finding that these goods were not fit to encounter the ordinary
Yes,
perils
well,
of
I was only making sure that I understood that that was your case, that the degree, in one sense, provided the risk isn't nil, in which case clearly it can't be inherent defect, and provided it's not 100% certainty, in which case you've got an inevitability defence. Wherever it is between those two, provided you can establish that those causes operated to cause the loss, you say you get home on inherent
Yes,
vice.
we do.
Thank you.
We do. We say that this is a very powerful case because the probabilities were so high. One couldn't argue that the goods were fit for the contemplated voyage.
But it has to be your, sorry.
Yes.
That's where I think I slightly lose you, because it seems to me that the degree of risk, 99.9 at one end and 0.1 on the other, is not a necessary part of your argument on the meaning of inherent vice.
No, it isn't.
Provided, of course, you can prove it, and I agree. If the facts are that the greater the risk can be proved to be, the easier you might be able to say is the proof that that's what caused the casualty.
Absolutely.
But that's as far as it goes.
That's as far as it goes.
And that is because you're measuring the percentage, whether it's 10% or 90%, against foreseeable weather conditions.
Well,
As long as you say 10% chance in foreseeable weather conditions, then by definition, unless one can say that it's the goods are nonetheless fit for shipment, i.e. any ordinary cargo owner and ship owner would accept a 10% risk as not rendering the goods unfit. Unless you can say that, then if the risk materialises, the cause is unfitness.
Yes, subject only to this, that there may be a question about precisely where you draw the line about usual incidents of the voyage. It's said by Professor Bennett that shouldn't include things that are merely foreseeable.
Yes, right.
We don't really mind about that because we're dealing with usual waves of South Africa. We're not dealing with a case which turns upon whether something is usual or unusual. What happened here must be usual.
You're dealing with habitual, to use
it would be even habitual. Yes. It's only if Mr. Pollock can get home on his argument that inherent vice is confined to the atmosphere in the hold, and that you must exclude from the hold even what happens outside the ship, which influences.
I don't think he goes quite that far.
Well,
What he says is that you've got to have what you exclude are fortuities and casualties. Is I think what he says.
Yes, but I mean, and the problem
with
with
Lord
that
Diplock.
But then he says the weather, atmosphere, cold is not a fortuity or a casualty. That's a difficult distinction.
It's a very difficult distinction, and it's not supported by any of the case law.
Well, it's not a terribly difficult distinction. Whether it's valid is another question. But I mean, the law has been distinguishing between fortuitous casualties and other events for generations.
Of course.
So there's no difficulty about doing it.
Well, there is this, that once you accept that the atmosphere in the hold is something which is part of the ordinary incidents of the voyage, it's very difficult to see why things that happen outside of the ship shouldn't be taken into account.
Well, Newton certainly does. I mean, the difference between the temperature in India and Rotterdam, but then the answer to that Mr. Pollock gives is that that's not a fortuity or casualty, it's just a fact of life.
Well, it must be a fortuity with respect, because what particular temperature you get on a particular day is a matter of risk. It's a fortuity. And I'm afraid that argument simply must be rejected. It's illogical. It's not supported by any authority. It's contrary to principle. It suits the case that's made, but it has no basis in the wording of the policy or any principles of marine insurance law. and that is why it must be rejected. Now,
Part of the trouble is that, some of these cases, the one you've just been citing to us is written in a day when I'm quite sure that the policy wasn't an all-risk policy.
no, that's true.
And now we've got anything can be a casualty or a fortuity,
And-
not just perils of the sea
True.
or fire.
But our policy has an exclusion of loss for inherent vice.
Right.
A lot of these cases don't have that exclusion, like Frangos and these other cases. The Star C, we don't even know what the policy provided. It must have covered fire risks, because that was the fire, and they found an exclusion in section 39.5. I doubt whether the policy had an exclusion for unseaworthiness or inherent vice, because I imagine that council would have relied upon it. So I don't think that that case helps. And Albacora, that passage in Lord Reed, again relates inherent vice to the contemplated voyage. And there the question was, is it a refrigerated voyage or an unrefrigerated voyage? Answer, an unrefrigerated voyage. You have to gauge fitness by reference to the unrefrigerated voyage. And the answer is, well, that's the end of it, they're fit. So you cannot answer the inherent vice questions, that's fitness and causation, otherwise than by reference to the contemplated voyage. True it is that you have to consider what you mean by the contemplated voyage. We say usual or ordinary incidents is the time-honoured phrase. It applies both in marine insurance and carriage contracts. Ordinary incidents, you'll see in Scrutton, you'll see it in Bradley. And where Mr. Pollock must pitch his tent is saying, well, the waves aren't part of the ordinary incidents. Now, he can't do it by reference to how high the waves were or the direction or anything of that kind. He has to say they're outside the ship. And with great respect, that cannot be accepted. And when we say that inherent vice and perils of the sea occupy different terrains, it's very important to be clear on what we mean. We say that when you look at the risk, that they are different risks. We are not saying that they cannot both be contributory causes. They can be. There is no reason at all why you can't have them as contributory causes. They occupy a different terrain in the sense that if you have a set of facts, as Lord Dunedin explained in the Leyland shipping case, where you have got a policy with perils of the sea and an exclusion, as you have in this case, you have to decide whether it comes within perils of the sea or the exclusion. But there are also two cause cases, and in those circumstances, it's enough for it to be a cause to get within the exclusion. And the Miss JJ is a very good illustration of that.
But basically, if you take the Sawyer and White test, and you assume that ordinary course of the voyage, it means that there will be inherent vice if there is unseaworthiness, unfitness. Nonetheless, it doesn't avoid the fact that there is still inherent vice, do you say?
Yes.
It doesn't avoid the fact there's still a peril of the sea, but in this case, under the clause 4,
We contracted to be free
you
from
contracted to be entirely free of all liability in that situation where there are two causes.
it. And that was part of the contract.
Has anyone, I don't think Mr. Pollock's really challenged that analysis of clause 4.
No. And can I say a word about the mortality cases? I know you've got to rise in a moment, but the animal cases, do you remember those about free from mortality? When you look through those, it was a question of the meaning of free from mortality and the exclusion. And you could have a horse that didn't actually die, but was so badly injured by perils of the sea that it was worthless. And Chief Justice Abbott says, well, why should you recover for that, but be excluded if the horse dies? That couldn't be the meaning of this warranty. That's ridiculous. And it's limited the exclusion to where mortality is the direct cause of the animal's death, natural mortality, and where there is no direct
So, I'm sorry, I
causation
don't
through
quite follow
perils of the sea.
what you mean by saying mortality was the immediate cause of the death, because it doesn't actually make
It
sense.
means a natural death.
A natural
Death.
natural
Mortality
death,
means
yes.
natural death. I'm so sorry, I've taken it too quickly. But that's the point. It's looking at natural death as opposed to unnatural death directly caused by marine peril. And that's how the policies were construed. And there's nothing really to be obtained from those two cases. Canada Rice Mills, if I can detain you for one moment longer.
It meant the warranty against mortality meant nothing, really, in
Yes.
those cases. Yeah.
Yes. And they say, well, look, you put it in the Lloyd's Coffee House. It's up to you to make it clear.
Yeah, right. No,
And
that's
if you don't use clear language, that's the end of it.
Yeah. Sorry.
Canada Rice Mills is actually a case where the case was tried by jury. And they had a finding by the jury on whether the rice was fit and whether it suffered from inherent vice. And the jury verdict was conclusive on that, or at least treated as conclusive. And then the case went on appeal solely on the perils of the sea. And so it was argued and decided on the basis that there was no inherent vice present. And one can readily understand why. The jury decision is at page 61 of the report. Now, Mr. Pollock said that you can't have a hull policy which insures against inherent vice. Of course, a lot of hull policies do at least insure against an aspect of inherent vice, which is the Inch Marie clause.
Sorry, just isn't Canada Rice against you though? The closing of the ventilators due to perils of the sea caused the rice to heat. That was a natural consequence of the rice. It couldn't stand a perfectly ordinary course of events. Yet nonetheless held the loss was not due to its inherent vice, but due to perils of the sea. You just
I would say
that's the jury's madness.
It's the jury's decision. Counsel may have got the wrong result from the jury,
Yes, I see.
but it doesn't tell us very much about what the law is.
Yes, I see.
Well, Mr. G, I think we've got to finish the oral hearing now.
Yes.
Unless there's anything you particularly in about 10 seconds would like to say to us. We're of course not shutting you out from completing your submissions in writing.
No. Can I just say this, that you will find in the appendix a long course of correspondence about whether there needed to be a respondent's notice in this case, whether there was an intervention in the Court of Appeal that wasn't recorded on the transcript, what was argued in the Court of Appeal in first instance on two causes, and we've got all the page numbers here, and you will find it all there, and that is reliable and accurate. And it is in, Appendix 1, pages 131, 132, 143,
Just a moment, Appendix 1, go on.
131, 132, 143, 163, and again 163. And 161, I'm told as well. And I won't take you all through it. Now, unless you've got any further questions to ask, those
I
are
think
our
not at this stage, Mr. G.
submissions.
Thank you very much. I think we'd like to thank both counsel for
Can I?
extraordinarily helpful and indeed interesting submissions. We clearly won't come to a conclusion on this matter until we've had the benefit of your remaining reply submissions, and you'll no doubt bear in mind that they are reply submissions.
Yes.
And after considering those, we will be in a position at some stage, I hope not in the too far future, to deliver our judgment on this matter.
Yes. Can I say that, Lord Savile, as I understand it, this is your last case you may be sitting, and from the bar, we'd like to wish you a very happy and successful retirement.
Well, that's extremely kind of you, Mr. G. I'm afraid the bad news is that although I will be returning as a retired Supreme Court Justice, you will see some of me next term.
could I just mention one point, which is, if your lordship could be very kind and through the usual channels let it be known in due course when judgment might come out, I'm asked to put this request to you by the editors of Arnold, who are in the process of having to prepare a special supplement, which will probably deal with the result of this case, which is intended to. So it would be very helpful to the editors of Arnold if at some stage they had some idea so that they could tell the printers and the publishers.
Well, we'll do our best, Mr. Pollock, but we're not going to give
I'm not asking
any
for a
form
commitment.
of warranty.
No, my lord, but
When the editors of Arnold want to buy.
if some information could percolate out at some stage, it
We'll
would be very
bear
helpful
it in mind.
to them.